You're not going to do that.
Okay, I think we're live streaming now. We'll get started. I may break up a little bit. My internet's not real great, but members of the committee are hereby advised of their duty under the State Ethics in Government Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from any matter coming before this committee with respect to which there is a conflict of interest or an appearance of conflict of interest. The minutes from the July 16th, 2020 are attached in your materials. I hope you had a chance to review those. They look in order. And I would entertain a motion at this point in time if somebody would raise their hand for a motion. David Allen, and second, someone raise their hand. Eddie. Second, the motion to approve those minutes. All in favor, if you will hit your yes button underneath your thing. I think that's probably the better way of handling it.
Yep, and that for those of you who haven't had to do it yet, it's in the participants button at the bottom of that list. You have yes, no, green check, red X.
Yeah. All right. So if you'll hit yes, if you are in favor of adopting those, please. Peter, you can tell me when to go.
Yeah, that's unanimous.
All right. First order of business is the review of the subcommittees that we have in this committee. The first one is the compensation of court-appointed defense counsel. Alan Cobb, Judge Cobb is the chair of that, and I'll recognize Judge Cobb to give us an update on the status and the activity of that committee, if you would.
I do not see Judge Cobb in here, Darren. Do you want to displace that matter and come back to it?
Or we can ask Alex if Alex.
I'm here. I'd be happy to do it.
All right.
The subcommittee the subcommittee on compensation of court appointed counsel met on October 7th. We ended up discussing an IDS memo that was basically a brainstorming session on how the state bar could provide assistance to private appointed counsel with the issues of compensation and high caseloads. There was some discussion about potential advocacy on behalf of issues related to what I just mentioned. And we did discuss that the state bar advocating on behalf of IDS or in relation to those issues is probably not the right way to go forward. Everyone on the subcommittee seemed to agree with that. And then there was a proposal that we instead conduct some sort of survey, specifically a survey of private appointed counsel, criminal law specialists and judges, looking at whether excessive caseloads and reduced compensation rates are preventing private appointed counsel from providing competent and diligent representation to their clients. And so I reached out to Brian to get some information on how to conduct that study, similar to studies we've done previously. And Brian and I haven't been able to get up to discuss that, but we will in the coming days, and then we'll get moving on that here soon.
Has there been another subcommittee meeting scheduled, or I assume you guys are going to wait until the survey's done, or how do you plan on acting on that?
That's a good question. I think what I wanted to do was get with Brian to figure out specifically how to proceed. I was going to send an email out to ask if anyone had any specific questions that they would like to include on the survey, and then compile something. And then at that point, maybe have a discussion whether we want to do set our next meeting or just send out the survey. And then when the results start to trickle back in, do our meeting at that point.
All right. Has anybody got any questions of Alex? Judge Cobb joined, Peter?
I don't think so.
Okay. Any questions of Alex? Just as a, IDS, I'm chair of the IDS commission, and I stay in touch with Mary Pollard, who's the new executive director, well, new as of August. She's still getting her sea legs under her, under that position. But I would just tell folks that I'm in constant contact with her, and we are getting reports all over the state of North Carolina from judges saying that they do not have enough court in districts. And this is becoming sort of a crucial point in how we're going to handle indigent defense, not just of criminal defendants, but also of civil litigants within the abuse, neglect, and family court. And in fact, I want to share one other thing with you guys just to kind of emphasize the danger and the concern that we have. Mary sent me an email this week talking about the fact that there was a law firm in Raleigh, a multi-attorney law firm in Raleigh, who themselves have 13 murder cases amongst their office. And they've had to start looking at restructuring their office because of the COVID situation. Out of 10 of those cases, 10 murder cases within Wake County, and they've already, their lists for attorneys who handle murder cases in that area, not just Wake County, but they reach out to surrounding. All the attorneys have either a maximum number of cases that they recommend that lawyers handle, or there's no lawyers there to handle the cases. So this is becoming really crucial, and I've asked Mary to begin to collect all those. I was hoping to be able to present them at some point in time, Alex, to that subcommittee so that we can look at that. It just reemphasizes the urgency of this problem. I don't know that it creates a situation that's going to make it so that we can, is a problem with that, and it's something that we're going to have to step up and at least try to get some of these other organizations like the Bar Association, NCAJ, to partner with us and hopefully get over to the legislature and talk about. So anyway, I wanted to let that know. There are situations where lawyers are getting too many of these cases and they're getting into disciplinary trouble. I've seen that already this week. So I just want to point that out. So any questions as regards to my comments that I just made? All right. The next one is on proportional discovery. That subcommittee is chaired by Gray Wilson. Gray, I recognize you to let us know what's going on.
Well, if you look in the issues packet, you'll see that I believe the bulk of the materials come from our subcommittee. But I tell you that by way of preface, because I'm reminded of a motorcycle club my father used to be in called the Big Wheels. And their motto was, "We do nothing, but we do it very well." And reminiscent of that, the committee has had several meetings, and we're been assisted by our able deputy counsel, Carmen Bannon. I see a couple of the committee members here. I may miss them all, but I see Walter Brock and Charles Hardy. We were able to have a decent meeting despite their presence. And we discussed whether or not the concept of proportional discovery should be revisited again in North Carolina in an effort to not only curb discovery abuses, but also to reduce the cost of litigation, which continues to mount. We first looked at the Federal Rule of Civil Procedure 26, which has a 2015 amendment in it that did list 5 factors to consider with regard to discovery, like how bad you needed it, how much it would cost, that sort of thing. And we have, of course, in Rule 26F of the state rules, at least under the certification provision in Section G, some reference to the fact that, you know, when you sign a document saying you're giving discovery responses, that you're attesting that they are proportional to the needs of the case. The query then came up about other avenues for proportional discovery in the state. And there was some reference to our arbitration statute for medical malpractice cases, where if you stipulate to that proceeding, there are definite limits on written discovery, depositions, experts, that sort of thing. Parameters that are so rigid that hardly anyone has ever availed themselves of it, to my knowledge. So the next question was whether or not it really fell within our regulatory wheelhouse proposed by one of the subcommittee members. And so we taxed Carmen with providing us information in that regard, and that's in your materials. And I don't think there's any dispute that discovery abuse, number one, does happen. And number two, there are multiple rules of professional conduct that apply in the event that that occurs for disciplinary reasons. So then we had our last meeting and had a discussion based on everything that we had reviewed up to that point as to whether, we would simply do nothing, or whether we would consider concrete changes to the rules of civil procedure, which would have to be steered, through another appropriate lobbying organization, perhaps our sister bar association, to result in actual legislative change before the General Assembly. And the other, was whether or not to try simply to roll in some of the language of the federal rule that's more or less aspirational about trying to keep your discovery appropriate and within limits. And after due discussion, there was polling, and I think unanimity was reached among the committee members that the rules that we have currently in North Carolina are sufficient to address discovery abuses. And to the extent the courts and the civil rules and the criminal rules of procedure are not satisfactory, certainly the state bar retains that disciplinary authority to address such abuses. And I can tell you from being on grievance, we had cases of discovery abuse, and they were addressed aggressively by grievance. So having said all of that, our ultimate conclusion was we're pretty good the way we are now, and we ought to leave it that way for the time being. And so we unanimously agreed to disband the committee in the wake of that ruling. And that's all I have to say about the matter.
All right, thank you, Gray. Anybody have any questions of Gray now that they've disbanded? All right. All right. The report of the subcommittee to study proposed regulatory change in other jurisdictions is Mark Enriquez is the chair of that. Mark, you want to update on us what you guys have been doing?
Yeah, I'd be happy to. You asked us to study, and I think we've been very studious in the committee. Just as a reminder, we started in June with Brian Oten providing a really excellent slideshow presentation showing us what's happening across the country, summarizing the changes afoot in a number of different states, not just out west, but really a number of different places. And I think we included that presentation in some of our earlier materials. In July, we had Professor Bill Henderson talk to the committee. He has been at the forefront of suggesting some of these changes and has written quite a bit about it. We had a really good dialogue with him about the reasons he sees these changes and kind of the focus on people law versus person law, corporate law versus people law, and some of the implications in terms of regulatory change. We decided we really wanted to learn more about what the need we're trying to address is. We know there's an access to justice problem, but we wanted to learn more about that. So we had another 2-hour meeting with legal aid professionals. We had George Housen, who's the executive director for Legal Aid of North Carolina, Jennifer Lechner, who's the executive director for the North Carolina Equal Access to Justice Commission, and Ken Shore, who has served as executive director of the Charlotte Center for Legal Advocacy. They each talked to us about what they see as the nature of the problem and what those unmet needs are. And it certainly is, it's significant in a number of different dimensions and fields, everything from from some of the criminal law issues you talked to a minute ago, Darren, to significant concerns in the family law area that most of our legal aid groups do not work on, to overloads on a number of specific areas, even where there is some legal aid, there's simply not enough people to do the work. We then considered in September whether there are technological solutions to the problem. We had a great presentation from Jeff Ward with the Duke Center of Law and Technology, talking about how technology and the internet and things like artificial intelligence and matching and some of the automation programs can maybe take the place of one-to-one legal services in some areas and help meet some of that need. And I think we had a lot of food for thought there. That's what we've been doing the last 4 months. A preview of what's to come. I think now that we've kind of done our deep dive into the nature of the problem, and an overview of what other folks are doing, I want us to start focusing on some of the specific changes that are being adopted to see whether that's something that might have applicability here in North Carolina. As many of you know, the Utah Supreme Court recently approved a regulatory sandbox that they're implementing. Regulatory sandbox is something some other jurisdictions have explored. So I think we're going to focus on our next meeting about what is a regulatory sandbox? What does it actually look like? Is that something that we could potentially do in North Carolina? Something else that a lot of folks have done and the Arizona Supreme Court recently approved is the idea of either a limited license person or a legal paraprofessional. The analogy is we've got a lot of nurse practitioners and other people that are assistive in the medical area that are not MDs, but are doing a lot of that work. And obviously we have paralegals, and we have a wonderful group of paralegals in North Carolina, particularly through our specialty program and the paralegal certification. And I think the question that we would address in that meeting is there something that fits North Carolina where we may increase the range of what either current paralegals can do or create some new category of limited licensure? So those are at least are two specific ones that I think we'll be exploring this fall. And then I think we're going to get together as a group and see, are there, in addition to those two, are there other areas that the committee feels like we need to do more of a deep dive in, with the goal that as we enter 2021, we'll be coming up with some recommendations and suggestions for what we think are the most fruitful ideas, if any, for North Carolina to then explore actually implementing in terms of policy change.
Does anybody, that committee is, I guess you've met 3 or 4 times now, and they have plowed a lot of ground already. And it is a committee that I think all the officers believe will be something that's ongoing because, well, there's a lot of work to be done. And I appreciate you, the spirit in which you took that on, and that is to sort of let's look at everything, no matter whether we thought it was a good idea or a bad idea. And so I think that'll continue on. So does anybody have any questions about of Mark about the committee's work? I think at some point in time, we're going to reap benefits from at least having studied those things. On the agenda, it doesn't show as it being new, but it is a new thing for our committee. And it is to consider some recommendations that to the officers back in June. And I'm going to recognize Alice to sort of go through those things and give us an idea of what the plan is with regards to how this affects the Issues Committee. Alice.
Thank you, Darren. As Darren mentioned, we received this memorandum from the LAP board in June. This was not long after the George Floyd killing and the racial unrest and protests that we were seeing from Black Lives Matter across the state and the country. It's a number of suggestions on how the state bar might address diversity and inclusion. I went through the list and made recommendations to the officers that there were several of the items that the LAP board simply has the authority to handle themselves. one of which was including a minority viewpoint in a column in their sidebar, which if you all are not getting their sidebar, you should be. It's an excellent online regular newsletter that is very good on mental health issues, and that the lab board simply has the authority to go ahead and include that if they choose. The other thing that was recommended is that Black counselors speak at the Minority Outreach Conference. Again, we informed the lab board that that's something that's completely within their purview to do. They also recommended that there be a minority viewpoint column in the State Bar Journal. We recommended that they take that idea to the publications editorial board to see whether they would embrace that idea. So those items sort of fell off the list. There was one item that I asked the Office of Counsel to review to see whether we would have any issues from a legal perspective. Catherine's office advised us that the suggestion that we recognize Juneteenth as a paid staff holiday was problematic. And so we basically said would take that off the list. Of the remaining items on the list, one was directed at the officers, asking them and other State Bar leadership, including myself, Ethics Council, Peter as Assistant Executive Director, and Catherine, to regularly attend the LAP Minority Outreach Conference, which is held in February, I believe, every year. I have been attending it. I don't typically stay for the full conference, but I've been attending it now for several years. And it's a phenomenal conference. Unfortunately, and Robin, I think, is on the call, but I don't think they're going to be able to have a conference, certainly not one in person in 2021. But the officers, as requested, have committed to attending that conference as a part of their regular duties and staying for the day's event to make that a regular part of the officers' activities. And we've added it to the officers' schedule of activities for each calendar year. The other item that I'm working on is, and I guess it's the 5th bullet point here, the recommendation that we enroll some section of the council in a structural training on race and bias. I've spoken with the folks at the Racial Equity Institute, which is an organization here in North Carolina. I believe they're based in Greensboro. And they're actually known at the national level for programs that they put on. And I've identified one. It's a short program that is interactive. It's gotten high marks for the quality of the programming. I think Barbara Christie has done a longer seminar with the Racial Equity Institute. And I'm looking at engaging them to put on a program specifically for the officers, the folks who are serving on these committees that are looking at the amendment to the preamble, the addition of section to Rule 8.4, and looking at the comment to the competency rule, include all of the counselors and advisory committee members that are serving on those bodies, and some additional staff folks and counselors to be part of that training. It's capped at 50 people. So my thinking is we do it one time and see if it's beneficial. And if it is beneficial, that we consider making it available to the entire council. And then looking at whether having an employee who is trained to do seminars and programs for the counselors, and particularly for new counselors when they're coming in, on diversity and equity issues, and maybe make that an in-house function that we provide. So those items in terms of the list of bullets here have all been addressed. What that left behind were a number of suggestions from the LAP board that I recommended to the officers be referred to the issues committee for further discussion and study. The first one is establishing a committee of the council that handles diversity and inclusion issues. And they recommended a person, meaning a staff person possibly, or a committee. The next item is research and adopting policies that support diversity, or at least do not disproportionately have adverse effect for minorities. Doing what's called a 360-degree association scan on diversity and inclusion. I'm not really sure what that is. I gather it's a kind of a audit of your organization to see how it stacks up on these issues. Promoting diversity at the district bar level in order to increase the number of elected Black and other minority bar counselors. Examining the bar council structure to determine whether it has an adverse impact on minority and solo lawyers, and evaluate whether there's changes that might help to address that problem. And then the last one is championing and promoting Black and other minority bar counselors for leadership positions in the State Bar Council. My suggestion to the Issues Committee is that all of these are worthy of study. As the executive director, I have to tell you, whenever we're talking about adding a new staff person, I get nervous because that means money and it means resources. And the same thing is true with a standing committee. Adding another standing committee to the council has other consequences. But I think the proposal is very worthy of study and consideration. And my recommendation would be that you set up a subcommittee to look more closely at what doing these things would entail, what costs there would be to it, benefits, or problems about doing it, any of these items.
All right. Robin is on the call or on this meeting, and I just want to give her an opportunity. If there's anything you'd like to say, Robin, since these initiatives have come from the LAP board. And I think, is Ted on here? Yeah, Ted's here also. So I would just open it up to Robin and Ted if y'all have any comments to make.
Sure. I want to thank Alice and the State Bar leadership for taking the memo into consideration. The memo was really just a brainstorm list of possible ideas. It wasn't a suggestion that the State Bar necessarily implement that, but to explore whether any of these initiatives make sense. It was really just offered up as, the State Bar taking the leadership role on these issues. So I think that's great if you guys do a subcommittee to study it. I don't really have much more to say other than we just brainstormed a whole list of possible ideas and included them.
All right. Ted, do you have anything?
Yes. Thanks, Darren. I really appreciate the leadership and Alice giving these proposals or ideas consideration. I guess I just would say that I think that we're in a time in our country where it's important for the State Bar to take a leadership role as it relates to these issues and to show that these issues are important. You can just look at the makeup of our State Bar Council. You can look at the makeup of this very committee and see that it's not representative. And I just think that we need to take action to address issues that do exist. And so I just hope that the committee, will take real action. I'm in the last of my 9 years on the council, and I do believe that it is difficult for minority counselors. I do think that we're in COVID times now, but even before COVID times, there were I have felt excluded from things. I have felt like an outsider during my time as a counselor. And so, I just hope that we can make progress in addressing these issues and and making our council more inclusive and more welcoming for minority attorneys.
Anybody have any questions of Alice, Robin, or Ted? All right, this being the,
I really want to thank Robin and Ted for their work on this and making these suggestions. I think this is a really important issue, and I appreciate them both bringing attention to the issue, but also brainstorming on ways to address it. I think that's great, and I really appreciate it.
I think,
Barbara?
Yes, thanks. Sorry, I had gotten kicked out, so back in again. So I don't know if I'm restating what someone said, but I hope that if a subcommittee is formed that, first of all, Robin and Ted, thank you for your leadership on this. And Ted, I hear you. So we all hear you. But that this would be not really defining the whole scope of that subcommittee.
We lost, I think Barbara froze up on us again.
Barbara? Okay. Let me, we'll see if she gets back plugged in. I did want to offer, this being the, oh, Barbara, are you there?
I am. I don't know why I keep freezing up here, but. So,
would you like to try to
no.
Okay. All right. So this being the last issues committee that I'm going to be chairing, I wanted to give President Willoughby, because this is his last meeting as president as far as the issues committee, wanted to get his insights on the work of the issues committee over the last quarter or year.
Thank you, Darren. I really would like to thank the issues committee for the work, and I think some of the most important work we do in the council is done here. We look at what the committees have done. I think this has probably been the closest that we've had for years to a proactive regulation, where we've tried to look at things into the future and try to look at issues that will address the practice of law and the protection of the public, and try to understand how we should deal with them. I think at least 3 of these issues that you've talked about today are going to continue on long-term for discussion and for our hopefully helpful work in making progress. You know, indigent defense, I think, is here with us for a long time, and we'll have to address that. I think regulatory reform, and I appreciate the work folks have been doing on this. I mean, it's really what Mark's committee and have looked at is pretty, I think a great way to go about this, to try to see what we think may impact us in North Carolina, what might be valuable and usable, what may not work here, may not, where the juice is not worth the squeeze on it, just to see. And also for the last, dealing with this issue of diversity, equity, inclusion, and how we address that, sort of tied in with the things that we're looking at now in ethics, with our look at the preamble, our Rule 8.4 and comments to 1.1. I mean, I think those are all sort of intertwined with our how we address diversity, equity, inclusion, both in the bar and in the courts. And I think those 3 are poised to be very important to us over the next few years. And I thank everybody for their hard work. It's y'all really have done a lot of work in between the sessions to get us where we are. Thank you.
All right. If you know anything about tomorrow night, we have the virtual reception, which is a chance for us to celebrate coming president and a chance to say goodbye to the outgoing president. And one thing that has just sort of kind of hit home is the fact the only officer who doesn't get to say anything tomorrow night is me. So I'm going to use this opportunity to just tell you that being an officer is like being one of 4 siblings in a family. You have the past president, who's Gray Wilson, who's sort of like the brother or sister who's gone off to college and is enjoying their life in a fraternity or a sorority, whatever the case may be, and really doesn't have a lot of responsibility, but comes home every now and then and helps. Then you have me as vice president. I'm the youngest. And because I'm the youngest, I don't have a lot of responsibility. I just, the only thing I did this year is of leadership purposes is sort of the issues committee as chair. And then I was co-chair of a couple, and it's been enjoyable and a learning experience. I learned a lot from Colin and Barbara, and a little bit from Gray here and there when he was home. But I was young, so I didn't get a lot of opportunity. And then you have Colin, who is ultimately responsible. The officers and the state bar does, and whether Colin actually has the workload to handle that, he always gets blamed and is responsible for that. And if you're wondering where I'm going with this, then you have Barbara, and I say this with all honesty, Barbara she is the workload. She's the one that carries the workload of the officers because she has responsibility for more as chair of more of the committees than any of us. And Barbara's done a great job, and I've learned a lot. And I spent 9 years of bar council with Barbara. And I want to say thank you, Barbara. I look forward to your leadership coming up. Thank you, Colin. I look forward to you getting onto your fraternity just like Gray was. And I'm really looking forward to having a little sister, Marcy, who we can help bring along, and she can help us as we try to make this bar council the best that it can possibly be. And that's my farewell speech as vice president. I'll see you guys all tomorrow night. Has anybody got anything else they want to say for the good of the committee or the council? Thank you for all your work. We will have a subcommittee, I assume, if Barbara decides to appoint the subcommittee, and I believe she would, for this last issue for LAP. But thank you for all you guys have done, and we will adjourn. Thank you.
Thanks.